Hello, welcome to Kinsmen Advocates Law Firm YouTube channel. If this is the first time you're watching our channel, please subscribe, like, and turn on the notification bell so you can receive more content. Today, we'll be discussing on how to get a divorce in Cameroon. This is a very sensitive topic as I've received requests from thousands of our clients across the world that we should talk on this topic. So today I'll be giving you the legal procedure to engage if you're contemplating of filing a divorce in Cameroon. Before that, it's very important to know that in the book of Matthew 19 verse 5, the Holy Bible provides that a man shall leave the mother and the father and live with the wife, and both of them shall become one. However, in the course of the marriage, there sometimes exist some marital differences which prompt spouses to contemplate of separation or filing a divorce. Now, it's very important to note that in Cameroon, the only recognized way to bring a legitimate marriage contracted under the law, is by filing a divorce. Our focus today is for us to enlighten you on the procedure to engage and bring a legally contracted marriage to an end, popularly known as divorce. Now, if you look at the provisions of the law, particularly section 1(1) of the Matrimonial Causes Act, which is the law that regulates the legal proceedings in filing divorce, it provides that there is only one ground in which you must present before the court to be able to obtain a divorce. And the ground is you must establish that the marriage between you and your spouse has broken down irretrievably. Now, there are certain conditions that must be complied with to establish that ground. And the very first condition of it can be captured in section 1(2) A, B, C, D, and E of the Matrimonial Causes Act regulating divorce proceedings in Cameroon. Now, the very first condition you must prove before the court will believe that your marriage has broken irretrievably is to establish that one of the spouse has committed adultery. Now, what is adultery? When a married person engages in sexual intercourse with another person other than the spouse. Now, you should bear in mind that this is the most difficult ground to prove in court. And that is because it is hard to get direct evidence, as the act of adultery is done in the most secret of all places. So most times, lawyers rely on circumstantial evidence and inferences to presume that adultery must have taken place. For example, in one of the celebrated cases that we handled in this firm, it was difficult for us to establish that there was adultery, but we used circumstances or circumstantial evidence. And we're able to prove that a man who drops a married woman at 2:30 a.m. at night, kiss and hug the woman before they bid farewell, there's a presumption that they must have engaged in adultery. Those are some of the circumstances we use to establish adultery if it's difficult to meet them in the act. Secondly, another point is to establish that either of the spouse finds the behavior or the character of the other intolerable. Now, this is the common ground that a lot of petitioners are those who want to file for a divorce, use in court, and they succeed. Now, some of the behaviors that you find intolerable of your spouse can be either excessive drunkenness, some spouses are abusive, some don't show love and care to their opposite spouse, some tell very expensive lies, some are very extravagant with the management of finances, and it might plunge your family into financial crisis. A lot of other behaviors depending on the circumstances of each marriage. In this case, you are just to establish that you don't find the behavior of your spouse tolerable. Further, Another ground that you can establish that the marriage has broken down irretrievably is desertion of spouse. Desertion is simply when you leave your matrimonial home and one of your partner is left behind. Desertion of spouse for a continuous period of at least 2 years. That is sufficient for the court to grant you a divorce. Now, also when the parties live apart for a continuous period of 2 years and they have consented to a divorce, the courts can proceed to grant a divorce. And finally, the last ground, you must establish that either of the spouses, they have lived apart for a continuous period of 5 years. Now, it is important to note that what the law courts are interested in is for you to prove any of these grounds. You don't need to prove all the 5, any of the grounds, and the courts can rule and grant you a divorce. Now, the question that I think it's very important for us to address is what happens in the case where there's a child and the parties have filed for a divorce. It's very important to determine custody of the child. Who is going to be granted custody of the child? Well, the cardinal principle in law when it comes to custody is which of the spouse can better guarantee the welfare and interest of the child. There are so many cases that there is no guarantee that a child of 2 months will be given to the mother on simple grounds that the child needs to be breastfed, if the mother's conduct cannot guarantee a healthy well-being or upbringing of the child. There are so many other cases where the man in question, that's the husband, is never around and doesn't even create time to talk to the child, but yet one custody of the child. The courts in so many celebrated cases have refused to grant custody of the child to such a man. Also, it is very common in our marriages in Cameroon for spouses to sign joint property regime. The joint property regime, when the marriage is being brought to an end, it's normal to hear parties saying that they contributed to either the construction of the house or the acquisition of the property. The law is clear. No matter the contribution of either of the spouses in acquisition of a property, at the level of divorce, the property will be sold and the proceeds shared equally between the parties. Now, it is important for you to hire a family attorney who understands the nitty-gritty of family and divorce law so as to have a proper presentation of your case in court. Now, I would like us to touch on some frequently asked questions by some of our clients who are contemplating divorce. They will ask questions like, I'm in the US or I'm in Europe and I want to file a divorce in Cameroon, but it's very difficult for me to come to Cameroon because of the nature of my job. Is it possible? The law is tried, and the answer is yes. You can file a divorce in Cameroon even if you're not in Cameroon. We've also received questions like, I want to file a divorce in Cameroon, but I don't know the whereabouts of my husband or my wife because we are not in talking terms and I don't know the address. How do I serve the divorce papers to such a person? Is that possible? The law is, it's very possible. Because in the matrimonial regime or in elementary civil procedure, service of court processes can be done personally, where you hand the divorce papers to your wife or to your husband, or service can be done substitutedly, when you have enough reasons to convince the court that it is difficult to reach your husband or your wife personally to hand over these papers. By substituted service, it means it can be served through publication and it can be served through any other acceptable means of service. We also received questions like, what can I do, or what are the criteria of the court for me to have custody of my child? And I emphasize The whole essence of custody is to ensure that the child receives proper upbringing and welfare. It doesn't matter how much you earn. It doesn't matter your faith. It doesn't matter your family. What matters is, will this child receive appropriate upbringing and welfare? That is the primary concern of the court. Thank you so much for tuning on to this channel. Thank you so much for watching. And if you have any question, please comment below and we'll respond to all your questions. Thank you.